You're listening to Economics Detective Radio. Guest today is Kyle Coates of Western Kentucky University. Kyle, thanks for being part of Economics Detective Radio.
Thanks for having me, Garrett.
So our topic for today is Wrestling with Intellectual Property, which is the title of a research project that Kyle is working on. That is a little more literal than you might think because it deals with intellectual property in the sphere of professional wrestling. So, Kyle, let's assume for this conversation that the audience has never watched professional wrestling. I don't think I ever have. Maybe I've seen it, in the background on TVs in public places, but it's sort of this odd area of entertainment where it's not a sport. It's not like watching Michael Phelps compete in the Olympics. It's not like Game of Thrones. It's not like some scripted piece of fiction.
Well, it actually has a lot more in common with Game of Thrones than you probably realize because it really is a scripted fiction. It's a work. It's fake. To use a derogatory term, I guess, amongst the industry and the fans, or hardcore fans, that is. But it's athletic contest between two people that's presented as an actual athletic bout with the intent to draw an audience and to keep those audience members coming. And in doing so, they actually the WWE has created its kind of own really meta universe, complete with its own cast of characters and storylines and things like that. So in a way, actually, it really is a lot like Game of Thrones.
Okay, so yeah, in some ways, very much like Game of Thrones. I've heard that it's somewhat got an improvisational kind of element to it as well, where the outcome of the match is clearly fixed, but what people do over the course of it is sort of more of a live performance with that's not always completely scripted. Is that correct?
Exactly, yeah.
So how does this relate to intellectual property law? How does this tie into your research?
Well, wrestling and intellectual property is kind of an odd topic, and our friend Ash Navabi, he put a panel together for this year's Southern Economics Association conference on intellectual property and asked me to do a larger project, which he wanted me to write history of intellectual property laws from 1710 Statute of Anne until the contemporary era, which is a little large of a project, especially for a weekend conference. And so I decided to narrow it down and look into intellectual property and pop culture. And as I was doing my research, I happened to see a story about two wrestlers named Matt and Jeff Hardy, who at the time were wrestling for an organization called TNA, and their contract had expired, and they were facing a lawsuit from their former employer, or I should say really more of a cease and desist than a lawsuit, over the intellectual property of the gimmick that these two gentlemen were doing. These two wrestlers, Matt and Jeff Hardy, had created a gimmick called the Broken Matt and Broken Jeff, Brother Nero. And essentially, it went viral. It was kind of the most popular thing on this one promotion, TNA, on their programming. And so when they left, this was a big deal to them. And I noticed that the cease and desist was based upon the Hardys' ability to draw a larger audience, and especially for going to the WWE. And they would have taken this property with them. And so I noticed that in the case of the Hardys in this broken gimmick, intellectual property was being used not so much for protection, but for anti-competitive measurements to keep a popular group of performers from using their newfound popularity on a larger stage and larger audience.
Interesting. So we compared it to Game of Thrones. This is sort of like, at least from the perspective of the network that they were on before, the wrestling organization. From their perspective, it's like if Kit Harington, who plays Jon Snow on Game of Thrones, went and reprised his role on a different show for a different network without permission of HBO or George R. R. Martin, right? From their perspective, hey, this character is something that was part of our universe, our IP, and just because you are the actor who plays it, you don't have any particular rights to that. Is that roughly how the wrestling organization saw it?
In the lens of TNA, yes, more or less. They had argued in their initial cease and desist that they had basically delegated the development of this new gimmick. It appeared on their television show, and therefore they were responsible and they had the ownership to it. The problem in the case of this Hardy gimmick, this broken gimmick, and for a lot of wrestling gimmicks as is they're not created by one person. Now, wrestlers, or I should say the wrestling industries, they have a large team of writers, and most of these writers will, they'll spitball ideas and they'll create these characters, and the performers themselves will help create the characters, and usually the company owner, like a Vince McMahon or somebody, will have input in creating these characters. So it's really a complex fusion of many inputs that create this intellectual property. And so in doing so, it really kind of creates a lot of ambiguities on kind of ownership. And even further complicating it is a lot of times these gimmicks are, for lack of a better phrase, they're kind of stolen or they're borrowed. For instance, there was a tag team in the 1980s of two men, and they were called the Road Warriors. And their gimmick was based upon that from Mad Max 2, the Road Warrior. And so they had the shoulder spikes, and they looked like one of Lord Humongous's henchmen, and that was their gimmick. And so once they, and I'm cutting a lot of some of their story out, but once they went to the WWF, Vince McMahon, or now it's WWE, but at the time it was WWF, Vince McMahon wanted to change their name. And he wanted to differentiate the Road Warrior product from his product of them now being called the Legion of Doom. And so in creating the name of Legion of Doom, that was explicitly borrowed from the old Super Friends television show. And so when they're basing their gimmick off of movies and cartoons and comic books, and there's multiple people creating these ideas and ownerships, for wrestlers, it really makes it difficult to understand and to view who has a property right to claim these ideas and this intellectual property.
And have the courts ever had to rule on this? Has it gone beyond the cease and desist stage to an actual lawsuit?
Yes, actually in 1990s, I believe the lawsuit was filed in 96 or maybe 1997. There was a big angle between in the World Championship Wrestling, WCW, which no longer exists, called the NWO, the New World Order. And the storyline involved three characters that had formerly appeared in WWF programming, which were Scott Hall was the first one, a gentleman named Kevin Nash, the second one, and eventually Hulk Hogan. And the storyline was an invasion storyline. So they played it as Scott Hall, who had wrestled in the WWF as Razor Ramon, and Kevin Nash, who had also wrestled in the WWF as Diesel, left the WWF to come to WCW with the explicit purpose of taking over. That was the storyline, okay? In this angle, Vince McMahon filed a lawsuit against Turner Broadcasting, who was the owners of WCW, and claimed that these characters were violating the intellectual property of the WWF. And so, for instance, in the instance of Razor Ramon, the Scott Hall character, Razor Ramon was based off Scarface. He had curled, long black hair, wet, toothpick he'd throw, scruffy face. He'd say things like, "Hey, yo." That was a terrible impression. He spoke in an accent. And in the lawsuit against the WWF said he cannot use any of these acts, these mannerisms, these gimmicks, these quirks, because they are the intellectual property of Razor Ramon. And what the courts decided was they said, well, WWF, you can't claim all of these little gimmick and these actions. You can own the character of Razor Ramon, you can own the character of Diesel, but since they've done these mannerisms and some of these little nuances, things that have made their character unique and individual before they were on WWF programming, that the performer has a right to the ownership of these kind of mannerisms and things like that. Or maybe I shouldn't say the ownership, but he has the ability to continue to use these mannerisms without violating the character IP. And so really in looking at some of the other court decisions, basically what it boils down to is if a wrestler has used some of those gimmicks, whether it be face paint or catchphrases or whatever, if they have used those before the copyright is filed or a trademark is filed on the intellectual property claims, then they are allowed to continue to use them.
So these characters then, is it the case, so the courts have essentially ruled that the name of the character is the property of, the wrestling network or TV show, but the gimmicks and mannerisms, at least in these cases where the performers use them ahead of time, belong to the performers, or the performers can use them without permission from the network.
So yes, that's generally true. However, what we've been seeing lately, and those court cases were in the 1990s, and it's important to keep in mind, or I should guess bring up some wrestling history, was at the time you had multiple competing firms. You had WCW, which was run out of Atlanta, and you had the WWF, which was run out of New York. And you had a few other smaller independent promotions. Now there's a lot more independent promotions, and there's essentially one dominant firm in the industry of the WWE. And so kind of the court's handlings of these have changed, because now what the WWE is doing is they are using cease and desist and lawsuit threats against some of their former talents and even some of the independent talents who they feel are violating gimmicks. So or property right claims. So for instance, there's a group of independent wrestlers called the Young Bucks, and they wrestle in Japan and for promotions called Ring of Honor, all over the place. And they do this gimmick where they say too sweet and they touch hands, because a lot of the NWO guys that I talked about a few minutes ago, they did that 20 years. Well, lately, or the WWF, or WWE, I should say, filed a cease and desist against the Young Bucks for using the too sweet hands gesture, which they said they had copyrighted and had an intellectual property claim to. Whether or not that's the case, I don't know if they have. I cannot find the WWE's trademarking and ownership of too sweet in this particular hand gesture. But they do have a comparative advantage with lawyers to prohibit their competition from doing this, which they will essentially sue and tie up their competition in courts, which will prohibit them from using these too sweet hand gestures.
Mm.
So it's really kind of depends on how the lawsuits are used and kind of how the courts have dealt with them. In terms of the U.S. Patent and Trademark Office and how they've handled gimmicks and copywriting names of wrestlers, it depends. It's very arbitrary because it depends on that particular patent official who's looking at it. Because the patent official can look at the copyright claim or application, and he can treat it as either a fictional character or as a service marker that requires the consent of that individual. So say the name John Cena, a very popular wrestler now. The name John Cena is trademarked because he had no problems in signing the name John Cena over to the WWE. In other instances, it's a lot more difficult and not that clear and dry, and a lot of it really depends on the arbitrator and how he looks at the material that's presented to him by the WWE, and whether he, like I said, views these as a fictional character or as a service marker that requires consent.
Yeah. So, for instance, there are people like Dwayne Johnson who started in wrestling. He was The Rock. And
Yep.
I believe, I can't be sure, but I believe that when he started appearing in movies, he'd appear on the movie poster as Dwayne The Rock Johnson, or they'd put The Rock on the movie poster.
That's correct. That's correct.
Do you know if they had to pay the Wrestling Federation when they used that, the name The Rock?
So from my understanding is when The Rock was advertised for his film, like his earlier films, and I'm not an expert on The Rock's films, so you have to forgive me, but like The Mummy Returns and some of his earlier, probably pre-2005 would be my guess, he was advertised as Dwayne The Rock Johnson because he was still under contract with the WWF or WWE. And so both sides benefited from him using the name The Rock. And so that it was not an issue. Once his contract expired, I believe in 2005, he was no longer advertised or marketed himself as The Rock. That's when he became Dwayne Johnson. Or you might hear like former WWF superstar, WWE superstar Dwayne Johnson. But once he was no longer under contract is when he stopped using the moniker of The Rock.
Interesting. So by contract, he had to use that moniker. So it wasn't him doing some other job and then asking for permission to use the moniker, because of course many people, at least early on, might not have recognized the name Dwayne Johnson if it wasn't attached to the nickname or the performer name The Rock. Today, I think most people would recognize Dwayne Johnson, but there was a branding issue. And so did they then, when he was doing other things in his career, when he was appearing in movies, I suppose the wrestling, WWE, expected a benefit from the additional publicity he was getting. Even though he was building his personal brand, he was building their brand as well.
Absolutely. Gain some trade.
Mm-hmm. So since both parties were benefiting, there was no issue and no need for litigation over that.
Exactly, yes. Correct. That is absolutely correct.
So in the cases of, in the other IP cases, I guess by implication, there wasn't a mutual gain. What's the pattern there between cases where you see people using their wrestling names and identities outside of their original context, where what's the difference between the cases like The Rock, where there's no need to litigate or have a cease and desist or anything like that, and the other cases you've mentioned?
Well, one interesting case, and I haven't really been able to verify this with hard, factual sources that fit my criteria as a grad student, aside from just some hearsay in some quote-unquote wrestler shoots, which means they just give these interviews, these candid interviews, I should say, not in character. Hulk Hogan, I believe, had to pay Marvel Comics for quite some time to use the name Hulk. The story goes that apparently he was with Lou Ferrigno at the time they were filming the show The Incredible Hulk, and somebody said, "Oh, Terry Bollea, who's Hulk Hogan, you have arms that are bigger than the real-life Incredible Hulk." And so that's how he got the nickname. And apparently Marvel had caught wind of this, and during the 80s and into the early 90s, he had to pay a fee to Marvel Comics to use the name Hulk. I don't know what that amount was, but that's a good example. And lately, since the collapse of WCW in 2001 and the WWF has become a monopolistic firm in the industry, one way wrestlers kind of get around not being able to use their gimmick names like The Rock in public is they legally change their name. So if you think of Stone Cold Steve Austin, well, Stone Cold Steve Austin's real name is Steve Williams. And when he was no longer wrestling, he changed his name to Steve Austin so he could appear as Steve Austin without having to pay the WWF or WWE any royalties. So name changing is one kind of market loophole or solution that wrestlers are using to still advertise themselves under their Gimmick names while no longer under contract with the WWE.
Okay, so right. So there's a loophole that you can't have the intellectual property over someone else's legal name.
Right.
One thing I think of is on The Fresh Prince of Bel-Air, Will Smith appeared as a character who was also named Will Smith.
Right.
And so the creators, the producers of Fresh Prince of Bel-Air can't now sue Will Smith in 2017 and say, hey, we own your identity and your name.
Right.
And that makes a lot of sense. It's a little bit of an odd application when their legal name changes, but it seems like it's it's beneficial, and like probably from a perspective of social welfare, we'd rather have established characters continuing to exist, and that facilitates it to let people change their names and continue appearing as those characters.
Mm-hmm.
Yeah, one. Well, I'm reminded of fan fiction, which exists in a legal gray area.
Yeah.
Usually it's permitted, but most of it is probably not strictly legal under IP laws. And so, you think of a wrestler appearing outside of his original context. It's a little bit like fan fiction.
Yeah, absolutely. And I think wrestling actually kind of depends on fan fiction. One thing that the WWE has done, I don't know, in the past 10 years is they've really focused on creating their own kind of universe. They refer to, like, for instance, they'll refer to their fans as the WWE universe. And within the WWE universe, they thrive on their fans having dedicated arguments over who should win and how this match should win and who should wrestle whom and what should happen and how the story could go. Because when the fans are invested like that, they're continuing to watch the program. They're continuing to buy the product. They're continuing to subscribe to the WWE network. And so for the WWE, and they'll even do things like they promote, they've got their own comic series, and they even have movies with their wrestlers in it. And so they want to create like this quote unquote real life universe of the wrestling product. And they also want to create a kind of meta universe for the wrestling product, which is harder to monetize upon. But this meta universe keeps the fans invested. It keeps them coming back, if you will.
Yeah. So it's one of these cases where, with the first case you mentioned, with the IP case where the wrestlers were appearing on another wrestling channel.
Yes.
That was a case where they were actively competing for viewers. So the original place where they appeared was maybe losing viewers to this other competing network.
Exactly.
But in some of these other cases, it's clearly complementary, where they're going to be more popular, and therefore people are going to go back and watch more wrestling.
Yes.
So in your paper, you tie this all back to the Coase theorem. How do you do that?
Okay, I'm a historian, so I only want to describe what is. I only want to make positive statements. And one of the things I was looking at was how can gimmick disputes be solved, okay? And wrestling, there's it's a big deal. It's called gimmick infringement. And the idea is each character, each wrestler, they have certain moves they do. They have certain catchphrases they say. They have a certain look. They do all these things to help get themselves over, to make themselves marketable to the audience. And there's different ways of solving these kind of gimmick problems. And in the wrestling world, and I'm going to use a term called Kayfabe, which means kind of the fake, we're going to pretend, the characters stay in character, the wrestling world. In Kayfabe, there was a solution or an instance where you had a gentleman, probably everybody has heard of, named Ric Flair. And Ric Flair, he goes by the moniker of the Nature Boy. And when he was starting out, he wrestled against a man named Buddy Rogers. And Buddy Rogers had wrestled in the 60s, and he was a champion, and big guy, big deal. Well, Buddy Rogers also went by the Nature Boy. And Buddy Rogers was retiring, and so to help make Ric Flair more popular, he had a match with Ric Flair, and the stipulation was the winner of the match gets to use the name the Nature Boy, and the loser had to retire. Well, in real life, Buddy Rogers was retiring, and so we see this kind of kayfabe Kosian solution of, well, who's going to be the real Nature Boy? And one way we're going to solve this dispute is we're going to have a match. And the winner of this match gets to use the Nature Boy. And that's exactly what happened. So that's kind of a kayfabe television storyline way of solving this gimmick infringement. Another way is there's this institution that is developed behind the scenes called Wrestler's Court. And Wrestler's Court is essentially a way where wrestlers police themselves for somebody breaking gimmick infringement or somebody doing something they're not supposed to. They're breaking the social order amongst the business, whatever. And the way that this Wrestler's Court works is you usually have one of the more senior, respected wrestlers acts as the judge. Both sides present their case. They might have another wrestler speak for them on their behalf. They might not. And then this judge makes a decision. And so here we have these ways of handling, like working out transactions costs and solving disputes amongst themselves and amongst a third party to help arbitrate these disputes.
Interesting. It occurs to me that by fixing the matches, it's clearly different, but there are some advantages over traditional sports where if the athlete who the audience really likes, who draws a big audience and gets a lot of people watching, doesn't qualify for the finals in regular sports, someone like Michael Phelps, then that's a loss to the people televising them. But of course, in wrestling, that would never have to happen because you can plan it out in advance.
Exactly.
So I guess the big question everybody's wondering about is, if Dwayne Johnson runs for president, can he use rock puns in his campaign ads?
Are you asking can he or will he? And let me rephrase it. Okay, I know you're asking. All right. So I think since Dwayne Johnson has been on such good terms with both the WWE and the McMahon family, I don't think that would be an issue. However, given that, and part of the neat story of wrestling is it fits into the kind of Rothbardian view of history of power versus market, and then market tends to, some of the market players kind of tend to become the state and so on and so forth, this evolutionary process. And with the McMahons, you've kind of seen that. They destroyed the path dependency of the previous system of wrestling when it was kind of a territorial southern, like kind of a cartel, if you will. And they really broke through like free enterprise in the market. They broke up the NWA and kind of the old wrestling way in the 80s and created the sports entertainment world of today. Well, now that the McMahons have become political players with Linda in Donald Trump's cabinet in the position of like the Secretary of Small Businesses or something to that effect, that complicates it because of the incentives. Because The Rock would probably be running against Trump. So I could see some legal action stopping him from saying some of his catchphrases, but I don't know. He could. Will he? I doubt it, but we'll see.
Yeah, we can only wait and see whether Dwayne Johnson will in fact run for president. You hear rumors that, in 2024 it could be Dwayne Johnson running against Oprah or something like that. And it just, I guess Ronald Reagan was an actor, so there is a precedent for this.
Exactly, yeah. Exactly. Well, at least you guys have Kevin O'Leary.
Oh, yes. Us guys meaning Canadians.
You Canadians, yeah.
Yeah, He did not end up leading the Conservative Party of Canada, but there was a time when people thought he might, and sort of very Trump-like figure, someone who plays a businessman on TV. But I mean, this is of course this is a bit of a tangent. Do you have any closing thoughts about wrestling and IP? What general lessons can we take about IP more generally from the lesson of wrestling?
I think wrestling illustrates, in regards to intellectual property, illustrates that one, it kind of shows the complexities of how an idea is developed. And going back to my example of the Road Warriors tag team, who were built upon, the ideas of Mad Max and I assume George Miller. I'm not an expert on the Mad Max franchise, but drawing from all these different source material really kind of illustrates that the complexities of trademarking and patent, or trademarking and copyrighting these ideas and these characters. It also illustrates that copyrights are often used in anti-competitive means. It's not done so much really to protect their property, but to hurt their competition. And also with intellectual property, it illustrates that the comparative advantages are very real in regards to the legal apparatus. And so it makes firms like the WWF, or WWE, I should say, gives them much greater advantage over their competition because of this. And so really, when I was looking at this, I was trying to illustrate how intellectual property tends to be more protectionist than it does to actually protect the inventor than it does to protect other firms or protect his interests from other firms competing.
Yeah, let's go down that route a little because we have more time. The idea behind IP, at its base, is if you have something where you can create something completely new, but it's easy for others to then come and copy what you create, there's a worry that people won't create enough new ideas, new things. The particular example we always see is new medical innovations, new drugs. And if you go straight from having the fixed cost of inventing the thing to being copied and having to compete in a competitive market, then your profits are zero and you simply lose your fixed cost, your fixed investment that you made initially. But then there's this other side to IP where once you've established someone's intellectual property in order to protect their right to earn a profit off something they've created, there are transaction costs and hold-up problems, and maybe someone who could be creating value, building on top of old creations, doesn't end up doing it because they're stopped by the IP holder. And there's a trade-off there, and I think what you're talking about, the protectionist side of things, is right. the bad side of that trade-off.
Correct.
We can use some other examples that come to mind from pop culture, the earlier ones than the wrestling examples, but when the Beatles were extremely popular in the 1960s, a show came out called The Monkees.
Yep.
Which was essentially just the Beatles with a different name, and they were the TV version of the Beatles. But they were a band and they had songs, and to my knowledge,
they had moppy haircuts and they dressed like the Beatles, and absolutely
there were 4 of them and everything. And but they created something of value. They created something new, and the Beatles were still extremely famous, still extremely successful. They probably didn't need any more incentive to create music, and probably even if there had been even more knockoffs, they would have been fine. So that's a case where having stronger IP protections for the Beatles to stop other people from having imitating them would not have benefited anyone. Clearly, another example of a Beatles knockoff was Chekhov on Star Trek was meant to emulate the Beatles. Yeah, so there are a lot of cases in pop culture where IP is not clear that having stronger IP results in better outcomes. People seem to have good enough incentives to create new music, new fine art, even without having an ironclad right to the derivatives of that art.
Exactly. And not just that, but consumers of popular culture, I think, are not as dumb as some of their critics have made them out to be. Critics of popular culture, like the Frankfurt School, tend to view consumers as these blind, kind of mindless drones that are willing to consume anything in front of them. And I don't think that's the case. And I think knockoffs in wrestling illustrate that. When we were talking about the NWO angle and Scott Hall and Kevin Nash leaving and they wrestled as Razor Ramon and Diesel in the WWF, well, the WWF said, hey, we own these characters. It wasn't the performer that got the character over. It was the character of Razor Ramon and the character of Diesel. And so they got two gentlemen that looked similar, and they learned the mannerisms and said the catchphrases and did the same moves, and it did not go over very well. The audience was very much aware of what was going on, and it did not last very long, nor was it very successful. And so I think the audience and consumers of popular culture, I could say, are very astute to both knockoffs and ersatz imitations. And, the people that watched the Monkees, it didn't mean that it wasn't a net loss for the Beatles. It's not a zero-sum game. It just means they're getting a complementary form of entertainment.
Yeah, and we
I don't think they're not rivalrous goods.
Yes, part of it is just that people can consume that particular the market in the 1960s for Beatles style entertainment, whether it's music or TV, was not saturated. People could listen to more music and they could watch more things. Similarly with podcasts today, I'm sure many of my listeners also listen to Econ Talk, and I don't think I've stolen many people away from Econ Talk. I don't think people subscribe to me and then unsubscribe from that show or from other econ podcasts. And so imposing some kind of intellectual property law where, if you're the first econ podcast with long form interviews, wouldn't benefit anyone. It would benefit the person who had that property right, but it wouldn't be socially optimal, I should say.
No, not even kinda.
So my guest today has been Kyle Coates. Kyle, thanks for being part of Economics Detective Radio.
My pleasure, Garrett. Thank you so much.
I hope you enjoyed this episode of Economics Detective Radio. And if you did and you're not subscribed, please go do that. You can go to your favorite podcast app on Android or iOS and just search for Economics Detective, find the podcast, and hit subscribe. That way you'll be notified every time there is a new episode. That is every week on Friday, for the most part, as long as I'm not super, super busy. And that is the best way to become a regular listener of the show, and I guarantee if you like this episode, you will like the other episodes as well. Thanks for listening, and I'll be back next week.